I don't think it's going to end well for you. I tried to save you from that the first day you were here when I tried to convince you to have some conversation with a court-appointed attorney, and you didn't want to do all that. I know in my heart of hearts, I have no ill feeling towards you whatsoever. And I'm going to give you the best trial I can give you today if you decide to participate. But I am not going to let you drag things in front of this jury that I determine are not relevant, because that's my job as the gatekeeper after the judge over the
lack of jurisdiction, the motion to recuse for bias, and the motion for relief from judgment. These motions have raised significant concerns about the court's jurisdiction, judicial bias, and violations of due process under both the Michigan Constitution and the U.S. Constitution, particularly the 5th and 14th Amendments. I have also submitted affidavits and motions, including an affidavit of truth and an affidavit of rebuttal regarding the traffic stop by Officer Merrill, which is connected to this case on August 21st, 2023. Citation number 24HR-101-430, which this court also ignored. These documents directly challenge the jurisdiction of the state in this court, and failure to address them constitute a violation of due process rights. Additionally, I have filed an affidavit of not consent, a motion for judicial notice, a motion for clarification of accuser, none of which may be acknowledged by the court. In Marbury v. Madison 5 U.S. 137, the U.S. Supreme Court clearly established that any law repugnant to the Constitution is void. I believe the action or lack thereof was supported by the fundamental constitutional principles. In Murdoch v. Pennsylvania 319 U.S. 105, the court reaffirmed that no state may impose fees or penalties for exercising a constitutional right, and Thompson v. Smith 155 reinforced that the fundamental right to travel freely without undue interference. Additionally, Title V U.S.C. 556D, 557, and 706 require that any judicial or administrative proceeding be fair, free from bias, and based on factual evidence. I have serious concerns that this court has disregarded this evidence. I have serious concern this court has disregarded these principles, given its method of dismissing my motions and statements made by Your Honor, who has stated on record that we see things the same way, referring to the prosecutor, township, state, and this court. This admission clearly demonstrates judicial bias and lack of impartiality, which undermines the fairness of these proceedings. It is also significant that Judge Tina Green has admitted in court that the Secretary of State is influencing the rulings, stating that the court is required to enforce certain rulings because of the Secretary of State makes them do so. This further demonstrates that this court is not acting as an impartial judicial body, but is enforcing motor vehicle codes, other rulings based on external directives rather than applying the law independently. The Secretary of State is an executive branch agency, and his influence over judicial proceedings is a violation of the separation of powers and the constitutional right to an independent, fair trial. Furthermore, there is clear evidence of collusion between the sport, prosecutor, Huron Township, including the Huron Township Police Department. I have submitted body cam footage highlighting violations of department policies by several officers, including Officer Merrill, Officer Syside, Officer Smith, and Chief Everett Lowes. These violations occurred even after Sergeant Price confirmed that my activities were lawful, yet this court continues to overlook these crucial facts. Officer Merrill's traffic stops of both myself and my wife are connected to the ongoing retaliation against me and my family, which has compounded the bias and misconduct in this case. Additionally, I have requested Your Honor's oath of office through an affidavit of fact, registration statement, demand request pursuant to the Foreign Agent Registration Act of 1938, and anti-bribery statement request, and I have received no response. This lack of response raises further questions about the legitimacy and legal standing of this court. Moreover, Judge Lisa Norton issued an unsigned default order without jurisdiction or court seal, and during court proceedings, she admitted she did not understand the sui jurisdiction. These actions reflect further incompetence and violations of due process. I must also address the township's deliberate attempt to mislabel my private automobile as an off-road vehicle under local ordinance to circumvent my constitutional right to travel. This mislabeling is an attempt to subject me to commercial regulations that do not apply to private, non-commercial travel. This ORV ordinance was never intended for public roads. Under the Clearfield Trust Code, versus United States 318 U.S. 363, when government entities operate in commercial capacity, they lose sovereign immunity and are subject to the same legal standards as private corporations. The court's actions, including the misapplication of commercial motor vehicle codes, further demonstrate its commercial interest in misinterpretation of the law. The Supremacy Clause of the U.S. Constitution, Article 6, Paragraph 2, mandates that this court is bound by the Constitution, which is the supreme law of the land. This court, however, continues to proceed without regard for constitutional protections, violating my rights at every stage of these proceedings. To continue under these circumstances would be a violation of constitutional rights and an abuse of the judicial power. I respectfully request that the court issue rulings on the pending motions, including a jurisdictional challenge, they immediately dismiss this case by citing overwhelming evidence of judicial misconduct, bias, and due process violations. So these issues remain ignored. I will seek immediate appellate relief, hold all parties accountable, including Your Honor, Judge Martin, Judge Tina Green, Prosecutor Caitlin Margaret Foley, Officer Miro, Officer Sisai, Officer Smith, Chief Everett Robbins, and the Huron Township Police Department. I further assert that if this court continues to proceed with the presumption that I engage in commerce, it must present evidence to substantiate his claim. Without such evidence, this court has no authority to enforce commercial motor vehicle codes or ORD ordinances upon me, and any further actions would be unconstitutional and unlawful.
All right, here to court, this report back in session.
Bring the jurors in. Mr. Crucell, just so you understand the process, we're going to do voir dire. Did you have a chance to talk about the iPad?
No.
Hold on a minute, Joe.
Yeah, I told him I would go over it.
Okay. I understand that's your position, but I'm still going to explain things as they go. All right. I mean, I just want you to understand what's going on. So if you decide you want to jump in, you'll know where you're at. Understood? I'm not trying to talk you into participating. I'm just letting you know what's happening. I'm going to explain things as we go for you and them. You got that?
I suppose I don't understand why I need to sit here and use my time for an phone.
Because if you leave, I'm going to ask you a bench warrant and you're still going to have to deal with this down the road. At least this way, listen. Here, one of two things can happen today if we have the trial. Either they find you not guilty and you're done, then you can file all your grievances and stuff, or they find you guilty and you're just filing one more appeal.
Well, instead of wasting everyone's time,
You've already wasted their time because they're all here. They're all here.
well, that's why I filed these things weeks ago. These things should have been addressed before this process even took place.
There's a scheduling issue that takes place too.
So I,
But hold on. Hold on. Don't interrupt. You didn't appeal the last round of decision. You didn't appeal the decision you didn't like from Judge Martin. You didn't appeal the decision you didn't like from Judge Green. And you didn't appeal the decision you didn't like from me last time you were here. So here's my problem. I'm not going to adjourn today because you say you're going to appeal, because if you don't, we've accomplished nothing and we're no further to resolving these files.
had to file with the appeals court that I've been in contact with the appeals court.
Okay. Okay, hold on. Let me try to educate you, okay? You contacting the appellate court, first of all, this should go to the circuit court, all right? You've gone, okay. So, I didn't choose for you to be here, but you're here, okay? So we have to get through it, all right? So the way it works is you don't just talk to them about an appeal, you actually file and perfect an appeal, but you didn't perfect the appeal. So there is no appeal. You started the process, but there is no appeal. So, Mike, we're going to go forward today. The only question is, are you going to be in the chair or not?
No, again, if you were prevent for, I'll participate on one, correct?
Depending on what I set the bench warrant at. It can be whatever I want it to be. Once again, but see, you think that's bias, right? And that's me explaining to you the way the process works. I could set a $10,000 cash bail on this. And until a circuit court judge tells me that's got to be set aside, it's the bail. That's the bond I set if I set it. Because here's the thing. And I'm trying to, listen, dude, I'm trying to get you to see I've got a job to do. It's got nothing to do with you personally. All right, you keep bringing this, I'm having so much trouble getting through to you. I'm thinking the next step is a competency exam.
So that fact that she told me that on the record in front of her, and in all the things that she's saying, the judge said, she never said that on the record. I have the record submitted.
So once again,
Told me she wasn't doing this because the Secretary of State.
then appeal Judge Green's decision. I've told you that at least 5 times today. If a district court judge makes a decision you don't like, you appeal it to the circuit court. You don't just keep arguing again. That doesn't get you any further along. So if you don't participate today, if you just sit there, that's fine. We'll have a trial. You can jump in if you want to. You don't have to. I mean, in any criminal trial, the defendant doesn't have to do anything. But at each step of the game, I'm going to let you know what your options are. So for example, when we do voir dire, I'm going to ask questions of the prospective jurors. She's going to ask questions of the prospective jurors. You can ask if you want to. You don't have to. All right. When it's time to pick the jury, she has a certain number of challenges she can use. So do you. You don't have to exercise those challenges, but that's the way we pick the jury. Do you understand that process?
I've been trying to get all this stuff established with the court's contingency. And I still have evidence that I'm trying to get from the township that they're using lead codes to redact, which they did with the policy information that I tabled and got them to give me the policy because they were trying to use leak stuff.
Okay, stop right there. Hold on. Stop right there. Stop right there. That's something new evidence you're waiting for. What are you waiting for?
This is rare. I haven't got it to even get to.
No. Tell me what it is. What?
Evidence that was that I requested from lawyers in the very beginning with my bottle camera.
No. But what is it? You're looking for some records, some ordinances? What?
Part of the traffic stuff, comments and things that were put in there that.
Hold on. In where?
In the comments.
You don't have police reports?
Well, I do, but I found out that they withheld certain documents that when I filed my FOIA, they didn't give to me. And then upon doing more filing for more stuff, I uncovered that they withheld certain documents. That are getting the whole thing.
Hold on. Let me hear what you just say. Just hold on. Go ahead. Do you have any idea what he's talking about?
He's bringing things from the south notes and
You mean like the officer's personal notes? Had notes.
for example, body on camera where they're sitting in their patrol car and the computer's on. Those are all lean material that can't be discoverable. It can't be shared with people outside of those that are have the security clearance to observe or handle the material. So that's what he's referring to.
Okay.
That's not what I'm referring to. The notes on the computers and stuff, that's not what there's even stuff that was in the body cam that when they were talking to the chief that they purposely redacted out of the conversations and the notes that that are completely all redacted. It's nothing to do with computers. It has nothing to do with personal information and names or addresses. There were things that were stated in conversations that were taking place in these notes.
Let me stop you. During the traffic stop?
I found out that they withheld this when they should have given to me in the very beginning with my FOIA for everything that's involved in my traffic stop. They didn't.
Okay, hold on. I'm trying to clarify. Are you talking about like, I don't want to say this. Personal comments between two or more individuals?
No, it's not personal comments. It was stuff that was logged through the traffic stop. Like,
No, stop. But I got to understand what you mean. Logged through the traffic stop. You mean it showed up on camera and then they edited the camera?
Yeah.
Or edited the recording?
As well. And there was no clear reasons why. Every time I try to get reasons to why they did it, what it's next, because they're supposed to label why it is. I haven't got anything. And then it's in the comments sections of like what was going on.
Hold on. Comments on the incident report?
It's not the incident report. It was through the, while the traffic stop was taking place, stuff that was being entered through, like, I can't remember exactly what the paperwork is I have. Like I said, I'm in the process of getting it all. I'm appealing to the supervisor, and then he vaguely gave, just cited statutes and codes, but he was supposed to tell me how and why I didn't even see the applying to the lead sections, which are failing to do because same thing with.
All right, so hold on. So what I'm hearing, I want you to confirm whether or not I'm hearing it correctly. I think what you just said was those comments section things that you want, they're telling you that's all lien stuff and it's protected.
Yeah, it's like, but I have other.
Hold on. Is that a yes? That's what they're telling you?
Essentially.
Okay.
So, and part of the, I had a whole thing of paper I got from them. They didn't do it in any of the other ones. Only.
Hold on. Other one what?
All the, because there have been several reports, several times the cops came out of their house, we were told, well, this has been going on for all of the years, probably why it's going to happen.
Okay.
So I filed every cop that had been there, all the reports, anything to do with anything that I could get that was access to me. And then that's how I found out that these other reports weren't released to me. And then in my life traffic stop, they did the same thing. Everything to do with that entire traffic stop is all completely redacted. But yeah, any of the other stuff, it's all open.
Redacted from,
The whole page is just black.
hold on. Redacted from the incident report?
Yeah, from the incident.
The paper report that you received?
Yeah, exactly.
Okay.
With no justification involved. So why any of these things are redacted, I keep trying to, and how they did it with the policy. I tried to get policy 3 separate times to the department, and then they cite these lien codes for names and addresses and stuff, which I understand there's certain stuff.
What policy?
The policy conduct for officer conduct and how the officer's supposed to operate themselves, right? So they denied several times, stating the same need codes are trying to fix all these connections now. So I appealed it to the township supervisor, and he released all of my information, and it showed that the policy showed that these officers violated the policy and you.
Okay, hold on, stop. So he released everything, but not everything you want?
Well, then once I realized they were doing this, I went back to getting more. That's how I know there was more stuff that was never released to me.
Okay.
And then doing the same process using these lien codes to not let me see what was put in this paper. And that's why it's all the record titles. I've been trying and fighting all this full time trying to get this stuff together. And I'm getting every which way I'm being screwed.
He's raising issues that concern me. Because now we're talking about discovery requests that are being partially fulfilled.
As it is with this stop, he does have the incident report. He does have body worn camera for 4 officers in car, dash cam, what have you. He also personally took video. I don't have it. There was no mutual discovery. He elected to use the FOIA route to take all this information. What he's referring to again is the CAD information where there is no material. None of that affects what the substance of the incident report or the body worn camera or anything of that effect. He's also talking about incidents that I think they were probably about the township attorney is dealing with it as opposed to the township prosecutor. There's probably about 20 different contacts that he has sought FOIAs through. So it's not just this incident. And what I suspect he's talking about where police may have came to his house or like a traffic stop or a speeding ticket, there are no incident reports. Those are CAD notes. So that's probably why those are blacked out as opposed to this incident where a misdemeanor was attached and an incident report had the event.
Okay. Anything else as far as information you requested that you don't have that you think you need?
I mean, that's the base of it. I'm still actually now that I've been having to really dig into stuff, I'm uncovering more now that I've been through the body cams. I have to file more to get more stuff unredacted because there is clear points in these conversations that were purposely redacted. They had nothing to do with clean information that they keep claiming. Same thing with these cat she keeps referring to. That's not what I'm trying to get hold of. And I understand that there are things that they can redact through the lien code. These entire things that are, there's no way the entire pages and these comments and everything are all lien information. There's no way. I've been told.
How do you know?
I've been told for Sergeant Price, things that are said in these personally about me and stuff like that that are being redacted because it can be used showing the bias and everything, the retaliation against me. And I know for a fact what was said in these things. That's why I know that being redacted is more than much to say.
Okay. But Mr. Crisell, with all due respect, that all sounds like a civil lawsuit against the township.
Well, yeah, this is my argument. I've been trying to bring into this court, but everything's just being keep getting.
Because I'm not going to get into all that with a jury.
But that goes directly to this, is what I'm saying, and that's why I've been trying to get all of this stuff answered before we even come to this point.
I'm not going to let you get into all that with the jury. It's going to be confusing. We're going to go down rabbit holes.
That's why I'm a little prepared because I need to be able to present my case to fair.
So this case goes back to February. We set this trial 2 months ago.
You're right, but
2
I'm
months and 2 weeks.
trying to get the jurisdiction established. I'm trying to get the judicial bio stuff taken care of. All of these things that have not, that they've just been it is what it is, just getting swept under the rug. When
Okay, hold on. Once again, I have to take offense to that. I'm not sweeping your judicial bias argument under the rug. I'm denying it.
I give it, yes.
Okay? No, seriously. See, it doesn't matter what you have to say. If I'm determining bias, I know what my heart is. Now, you appeal that decision or you grieve me to the Judicial Grievance Commission, right? They can look at all your facts and say, well, Oakley, clear bias. But I don't have to hear all your arguments and see all your evidence to know I'm not biased.
That's fine. I guess that's something, and I have already started the process. I will be going down it. The more I look at it,
Okay.
So again, I,
Sir, it's 9:02. The jury's been here since, I'm assuming shortly after 8, some of them were showing up.
yeah, like I said, I cannot participate in something that I know is not, is stacked against 100%.
Well, once again, you think it's stacked against you just because you don't agree with the way things are going. Okay.
It shows that these things have to be established, that there has to be a.
Then,
You see, bias, but that, to me.
okay, stop. We're just hashing the same arguments again. If you're right, then you've got an automatic appeal if they convict you. If you're right, and this whole thing has been nothing but a sham.
It has to be, and it's all this turned into.
Okay, bring the jury in. I'm tired of talking.
That's the motion will be real quick.
Motion who? Oh, I forgot you filed a motion. Give me just a moment. Yeah. Yeah. Did you see that? Hold on. Did you get her motion?
I never seen anything.
Yeah, no. Just, you got a copy, you can just at least show him so he can see if he's seen it before.
When did you send this to me?
Last Tuesday along with our motions.
I have never seen this.
Take a minute to look at it.
I would also like to bring up for the record too that.
Hold on. Hold on. Have you had a chance to look at what she just handed you? Okay. All right. So are you ready to argue that motion?
Well, no, I had no time to prepare for anything except. I've never seen that before. And
Okay.
it's just trying to keep me from being able to bring up all my valid arguments that are all applied to this.
Once again, valid as you determine them,
It's advanced to the case.
as you say.
And that's, and they're saying with the things they're trying to say, right? They have no evidence. Where's the evidence, right?
Right. But I haven't ruled that anything she's trying to put in front of the jury is invalid.
So my defense to my.
Well, here, let's do it one at a time. She wants to stop you from saying anything about due process violations. Did you plan on telling the jury that your due process rights have been violated?
All part of this case.
Okay.
Same thing with all the way from the traffic stop all the way till now.
Specifically, what were you going to tell them about your due process violations?
Well, I don't have my defense completely in front of me because I'm, again, trying to get all the other matters. I'm not ready for that. So, and I've never even seen it, so I can't even build up a defense to that.
How was that provided to Mr. Crisell last week?
That's responsible.
Okay.
I received his motion, or his 109 motions on Thursday, so it didn't give me much time to respond. I did send it in the mail, I dropped it off at the post office. And I didn't receive his most recent motion.
That was filed Friday. Right.
I sent a letter certifying else, so I know the shit's in. I mean, we've never had first class name. Never.
All right. So here's what we're going to do. If you decide to participate and present any evidence to the jury today, then if any of these A through E's come up, we'll deal with those as on a point by point basis. Understood?
Yeah.
I'm not,
No level.
sir, I'm telling you, you don't have to. She wants me to give you a blanket instruction right now that you can't talk about any of these things that are listed in this motion. I'm not going to do that. If you choose to present anything to the jury and one of these topics come up, she's going to stop me probably with an objection, say, Judge, could we talk about that? And then we'll talk about that. Item by item. Understood? All right. Anything else before we bring the jury in? You said you wanted to say something before the jury came in. I thought you said.
Another key point to this, I filed for, records requests in court, trying to get all my court hearings and everything in recordings. There's still one from the very first one from Judge Martin that is crucial to this case. They still have issues.
How could it be crucial to the case today?
Yeah, second rule in there are absolutely huge to all my whole.
No, they're not. No, they're not.
All of this.
No, sir, everything started on February 3rd, 2024, when your tickets were issued. So anything,
Then I take it as default.
let me answer. I'm trying to be patient, Mr. Crisell. Anything Judge Martin said at a hearing about those tickets after February 24th, February 3rd, 2024 would not affect the facts of what happened on February 3rd. Agreed?
But it affects what is going on with this court, as far as the fact that.
The only thing that's going on with this jury is deciding what facts took place on February 3rd and how they apply to the ordinances the township is trying to apply.
Yeah, then getting thrown out of that, but like I said, I'm not gonna subject myself to sitting here through something that I know.
Then get up and leave, Mr. Crisell. You're not under arrest. I've already explained your options. I've tried to be as clear as I can with your options.
Like I said, I will not participate in this. It was clear there's all sorts of stuff going on here that's great against me.
I understand you feel that way, but I've got a trial scheduled today. Something's going to happen. Once again, if you get lucky, they find you not guilty and you're done with this stuff.
Can I take a minute to figure out what I want to do with this?
Absolutely. Oh, one thing I want to make clear. The civil infractions don't go to the jury. You understand that? That's a formal hearing. That's just between us. You understand that? We'll deal with that after the trial if we have a trial today. The misdemeanors will be in front of the jury. You understand that? Okay, take a minute. Make it quick, though. I hate to have the jury wait. All right, back on the record with the People versus Crisell. All right, Mr. Crisell, I just want to put on the record the conversation that we had out in the hallway with Mr. Bowditch present. Outside of your hearing, by the way. Apologize for that. But I filled you in. So you've agreed you're going to pay your $300 contempt charge. I put that in air quotes. I'm going to apply that towards the cost to pay this jury panel for being here today. Agreed? In exchange, we're going to pick a date, hopefully in the next 2 minutes. We're going to pick a date, put this back on our calendar down the road to give you plenty of chance to perfect your appeals, whatever you want to appeal. Agreed? Okay. All right, you can sit down. Okay. Now, but I have to say some other things. All right. Before I took the bench, I did a lot of court-appointed work. All right. So I know that a lot of times when a defense attorney's talking to their client, they've got to get over a mental hurdle because a lot of people in a situation where the court's provided the attorney, they think the attorney's not working for them. The attorney's working for the court. So I want to make sure you understand how this works. Mr. Bowditch, although we've worked together for years, he doesn't work for me. Really, he doesn't even work at my pleasure. I suppose if all 3 judges in this court told the Michigan Indigent Defense Council Regional that he works for that we just don't want this guy in our courtroom anymore because he's just incompetent or whatever, they'd probably put him somewhere else. But other than something drastic like that, he's not here because I'm paying him and I've requested him. You understand that? Okay. His job, his client is MIDC. And I say his client because they pay him. But he's paid to represent folks in district court that don't have their own attorney. I just want to make sure you understand when he's giving you advice, he's not telling you what he thinks is best for me. He's telling you what he thinks is best for you. Okay? Now, the other thing, I'm assuming he brought my offer out to you. Listen, if you want to get into all those arguments that you've referenced today and the last time you were here, I'll give you that. I mean, I'll look at all the stuff you've got on the traveling argument, everything else, because what I told you earlier is I've got an open mind. Okay. I don't think in my heart of hearts, you can convince me that your argument on traveling is a valid one, but I'll listen to everything you've got to tell me on that and every other issue. I mean, I'll give you an entire day set aside for a trial to do all that, but not with a jury. All right. So I want you to know that's an option. I'd like, and if you need to have some conversation with your family or Mr. Bowditch, I'd like a decision on that today because when you walk out of here, I'd like to have a date on the calendar for either a bench trial or a jury trial. Okay. And I hope based on my earlier conversations, you understand why I can be much more free and easy about what I let in when it's just me making the decisions than it is with a bunch of jurors. All right. Bowditch, go ahead.
We actually adjourn this, now, Priscilla and I have had a conversation. I think we can streamline this case quite a bit. Could we set another motion date? It's nothing that's been covered. We covered new ground.
Okay.
This would be a simple motion, with his understanding, it's yes, no. And then if we need to proceed to a bench trial, we would.
How far down the road?
Well, it depends on how long his discovery is going to take, if there's anything even possible to be retrieved. But I still have a month or so.
Probably a month is too tight.
This talking.
Well, I know that's in the process. I've already appealed to the conference. I'm in the process.
Okay. Hold on. I think so. October 21 is too tight, I think. October 21, I think is too tight. Time frame wise, you want to go into the next month?
We can, Your Honor, it's up to the courts.
I have no idea how that process is gonna work, so I don't
Yeah,
know.
I mean, I'm first time.
With what the court's done today and asking more favors.
No, you're not asking a favor. We're just scheduling a date.
Do you do?
What is it?
That's a Monday before Tuesday.
Yeah, that'll be
We'll
safe.
open that day.
That'll be safe.
If Caitlin is.
Do you have, an opening on Monday, the 25th? You're not scheduled.
Of November.
Just for a motion. This is just a motion hearing. We're not gonna take testimony. Okay.
As long as you're not, no,
Don't-
you don't have them that month, it looks like.
So that'll work?
What's the date?
9 a.m., the 25th of November? It's the Monday before Thanksgiving. Nobody's got travel plans?
Motion date.
Okay. So I think what I'm hearing is you think that will either be dispositive or we'll set a trial date that day.
Yes, Your Honor, or we'll resolve.
Okay, all right. Okay. I didn't ask. Can you pay the $300 today? Okay. And I implore you, keep talking to him. Keep talking to him. All right. Anything else? All right. We're adjourned. Yeah, go ahead.
Officers are here and you guys are ready to testify if you want.
Understood. And you can give them my apologies. Put it all on me. So your civil infractions, we're just kicking those down the road. Understood? Okay. Or I keep saying infractions. It's 2 misdemeanors, 1 civil infraction. All right. Okay, so everything's adjourned. I'll make a note in the file so the cashier knows what to do with your $300. Did we set that at 8:30 or 9?
You said no.
We set it at 9, but if he's always here early, she'll probably be here early. So get here early. We might get it done with. You're not late if you're not here before 9, but just telling you. Okay, we'll get your notice. You're good to go.
You're on the cashier, correct?
Yeah, I got money, you got this on.
Thank you, Your Honor.
Thank you, Mr. Bowditch. I appreciate the efforts. All right. Caitlin, enjoy your Monday.
In this legal case, we observe a defendant appearing before a district court judge while challenging the fundamental authority of the township to prosecute him for traffic-related misdemeanors and civil infractions. The defendant, appearing without conventional counsel, relies heavily on sovereign citizen-style arguments. He asserts that he is not engaged in commerce and therefore cannot be subject to local motor vehicle ordinances, invoking the constitutional right to travel. Furthermore, he alleges deep-seated judicial bias, collusion between the local police and the prosecutor's office, and a failure of the court to fulfill his discovery requests regarding police body camera footage and incident reports. The prosecution maintains a standard stance, arguing that the discovery requested by the defendant involves protected, sensitive information referred to as LINE, Law Enforcement Information Network, material which is not subject to public disclosure. The prosecutor clarifies that the defendant's various requests for documentation regarding unrelated police contacts do not constitute relevant evidence for the specific charges at hand. A key moment in the proceedings occurs when the judge attempts to explain the necessity of the trial process, distinguishing between a jury trial and a bench trial. The court consistently rejects the defendant's claims of bias, noting that the defendant has failed to follow proper appellate procedures, such as seeking relief through the circuit court. Instead of ruling on the defendant's motions to dismiss, the judge encourages him to focus on the facts of the incident date. Ultimately, recognizing the stalemate, the judge orders the case adjourned to allow the defendant time to coordinate with counsel and perfect his filings. The defendant agrees to pay a $300 fine to cover the costs incurred by the summoned jury, effectively resetting the calendar for a future motion hearing in November. If you found this breakdown of courtroom procedure insightful, please like this video and subscribe to the channel for more legal analysis. I would love to hear your thoughts on these types of jurisdictional arguments. Comment down below and let me know your perspective on how courts should handle these complex defense strategies.